Ladies and gentlemen, good afternoon and welcome to this academic ceremony. It is a pleasure and an honor to receive you at ISS, the International Institute of Social Studies of Erasmus University Rotterdam. This afternoon, Dr. Karin will deliver her inaugural address, and with this will officially assume her duties as Professor of International Law and Development. A warm welcome to you, Professor Arts. And of course, a special, cordial welcome to her husband, Dina, and their children, Fabian and Ramon. Moreover, I bid your relatives and close friends present here a warm welcome. And last but not least, I welcome all staff and students of ISS. Of course, you have all switched off your telephones. But would you do me a favor? Check it one more time. It really is switched off. Thank you. You could think of that. Karin Arts joined ISS in 1988 and since then has built up wide teaching and research experience in the fields of international law and sustainable development, international human rights and children's rights. She obtained her LLM degree from Leiden University and a PhD from the Vrije Universiteit Amsterdam in international law. She advises the Dutch Parliament and the Ministry of Foreign Affairs through her membership of the Public International Law Advisory Commission and the Human Rights Committee of the Advisory Council on International Affairs. She also advised several NGOs in the fields of EU development cooperation and children's rights. And of course, we know her all very well as member of various committees in ISS. Professor Arts, I would like to invite you to take my place and deliver your inaugural address, Coming of Age in a World of Diversity. And you will explain us why the question mark should be put.
Mr. Rector, Your Excellencies, colleagues, students, relatives, friends, ladies and gentlemen. In 2 days from now, this Saturday, the United Nations Convention on the Rights of the Child will celebrate its 21st birthday. And apart from an occasion for birthday cake, perhaps certainly this coming of age is an appropriate occasion to assess the Convention, from now on in short the CRC's, performance records. After all, across several countries and cultures, the age of 21 is regarded as one of full legal capacity and, at least in a formal sense, full adulthood. This focus is also fitting from the perspective of the professorial chair in international law and development that I hold. That chair is devoted to studying the role of international law as an instrument of change and/or a constraint for realizing equitable development and human rights around the world. Human rights-based approaches to development are a central theme in this regard. The CRC then is an obvious subject for various reasons. First, at present, both across so-called developed and developing countries, pertinent issues arise. Pertinent societal and developmental issues arise around children and youth. Children and youth make up a big part of the population, especially in developing countries, and are the future of all. We all know examples of child abuse and exploitation and of failures in providing all children with decent living circumstances, education or healthcare. These issues need to be addressed. And as I will explain during this lecture, the CRC provides a highly relevant framework for doing so. Second, the Convention is a prominent example of a global international law instrument that both seeks to confront and address development challenges. Its drafters were very much aware of the fact that this treaty would have to be realized across many different countries, cultures, legal systems, economic, political and other relevant circumstances. As a consequence thereof, a real effort was made to formulate space for contextual interpretation and accommodation of all the diverse circumstances in which children's rights are to be implemented. This package was then embraced by the world, as the CRC is the most widely ratified global UN human rights instrument, with 193 state parties at present, and that is all except Somalia and the United States of America. It has generated an unprecedented level of commitment, both among state and non-state actors. Studying the CRC experience will thus deepen our understanding of the particular role of international law instruments for development and positive social change. At the same time, the constraints that may arise in this context also become apparent. And the last, more personal set of reasons for zooming into the CRC realm is that it is one to which over the years I have become particularly committed, personally and academically. And this commitment has been nourished and deepened by the considerable teaching on children's rights that I've done here in the ISS and by work done on projects and publications. And the field and other exposure that I've had to child rights issues in, among others, Palestine, the Philippines, South Africa and Sudan have shown me that even in very difficult circumstances, child rights-based approaches have much potential for improving the quality of children's lives. And in the years to come, I look forward to finding opportunities for developing a more pronounced line of research activities on the Convention on the Rights of the Child and its role in processes of development. And this inaugural address marks that agenda. After a brief reflection on the current state of children's rights in the world, I will elaborate the argument that the CRC is an especially relevant global international law instrument that contributes to development processes across the globe. I will explore the extent to which it has contributed to the aim of universalizing children's rights and explain what was and what is involved in this process. The content of the CRC, trends in the ratification record, and its impact on national legal systems will be briefly reviewed. All of this will provide ample material for assessing whether the Convention does indeed live up to the expectations linked to its coming of age, its 21st birthday. Has the CRC become fully mature, and is it adequately equipped to face the many challenges that exist for children's rights? Is it a useful instrument in a world that is so strongly characterized by economic, social, political and cultural diversity? Is it a fitting tool for addressing the persistent inequalities that determine the situation of children in different parts of the world? At the end of this lecture, all of you can pick up a copy of the written and fully referenced version of this lecture. I wanted the cover of this booklet, which is displayed on the screen now, to express my reading of the situation of children's rights in the world. And it's really hard to do that in one or two pictures. However, award-winning Palestinian journalist Mohammed Omar kindly made this possible by allowing me to use two of his pictures. The situation of the Palestinian people and the impasse with Israel over it are an affront to international law and to development and human rights goals. Children make up 53 to 56% of the Palestinian population, depending on where you count. Their lives and development potential are dramatically affected by the ongoing violence. Both cover photos show scenes from the daily life of children in the Gaza Strip. The top photo shows two girls collecting what remains of their belongings after Israeli bulldozers demolished their house in Rafah, southern Gaza Strip. It represents destruction, chaos, and unfulfilled and violated child rights. The bottom one shows two different Palestinian girls playing at Holy Family School in Gaza City. And to me this scene represents joy, peacefulness and fulfilled child rights, which remarkably and fortunately also exist amidst chaos and harm, although much less than should be the case. To set the context of this lecture, it would be appropriate to present the current state of children's rights in the world at the outset. However, that is not as simple as one might think. Assessing and measuring human rights is a complex thing to do, for both practical and methodological reasons. Primarily on the practical side, relevant statistical data are often not available and or lacking disaggregation, notably by age. Baseline information is often missing as well, which makes it difficult to develop credible assessments of whether human rights records have improved or deteriorated over time. On the methodological side, complications may arise in defining the human rights to be measured and in developing indicators. Most human rights problems have multiple causes, some of which interact dynamically with others. Coupled with problems of establishing direct causal linkages and of attribution, and coupled with time constraints, this often makes human rights measuring exercises complex and ambiguous undertakings. All of these complicating factors frequently stand in the way of achieving fully reliable human rights measurements. All too often, their content is driven by value judgments or preconceived ideas about a given situation, the standards or the issues at stake, or by existing political agendas, formal organizational mandates, donor requirements, or other rather subjective, if not overtly biased, considerations. Specifically as regards children's rights, conceptual confusion between child well-being, child welfare, needs and rights has also barred accurate assessments of implementation levels. In light of all of this, it should be no surprise to you that it is impossible for me to give an unambiguous account of the state of children's rights worldwide. Instead, various readings of the situation, both positive and negative, are possible and can be substantiated. In view of the time, I will only present 2 or 3 examples each of, respectively, progress made, stagnation, and regression in realizing children's rights in the world. According to combined, and now we are in the realm of progress for children's rights, according to combined UNICEF, World Health Organization, World Bank and UN Population Division data, during the period 1999 to 2008, child mortality under the age of 5 reduced by 28%. On top of this positive indication, in 2010, scientific evidence showed that the figure used thus far by UNICEF on both child and maternal mortality presented an overly pessimistic picture. Through using larger data sets and new and more accurate calculation methods than before, medical researchers found that in 2010, 7.7 million children under 5 will die, rather than the UNICEF estimated number of 8.8 million. Although this lower figure obviously is still unacceptable, according to some of the researchers involved, the new evidence suggests there is much greater reason for optimism than has been generally perceived, and that substantial decreases are possible over a fairly short time. In the Netherlands, in 2010, the Dutch branches of Defence for Children International and UNICEF reported numerous positive achievements for the realization of children's rights as well, including a reduction in the waiting list for youth care, the decision to appoint a children's ombudsman, and the right of children to be provided with assistance by a lawyer or person of confidence during a police hearing. Now the realm of lack of progress for children's rights. And despite the positive developments which I've just mentioned and others which you will find in the booklet, obviously still many sobering facts about child survival and development remain. The 2 leading causes of under 5 child mortality are pneumonia and diarrhea, both easily preventable and curable diseases. And shocking regional differences exist. According to UNICEF's 2010 Progress for Children report, and I quote, "A child born in sub-Saharan Africa faces an under 5 mortality rate that is 1.9 times higher than in South Asia, 6.3 times higher than in Latin America and the Caribbean, and no less than 24 times higher than in the industrialized nations." A second sobering fact relates to the issue of birth registration. Chances for protection, provision of material needs, formal education or healthcare, and official participation are usually much more difficult to obtain for a child who does not exist in official records. Nevertheless, in the developing world, only half of the under 5-year-olds have their births registered. In the so-called developed world, grave child rights issues exist as well. The prevalence of child abuse and the treatment of Roma children across Europe are just two of many examples. In fact, deeply troubling trends are unfolding in some developed states, especially in the realm of immigration and the treatment of so-called illegal or undocumented migrants, including children. For example, in the Netherlands, the situation of minors who have no residence permit is worsening. Ever more of these children are detained. Family reunification requests are increasingly rejected. And in recent years, various authoritative international bodies, such as the United Nations Committees on Racial Discrimination, Torture, and the Rights of the Child, the European Committee of Social Rights, and the European Court of Justice have criticized and at times harshly condemned certain elements of Dutch immigration policies. Rather than taking such international criticism to heart and embarking on swift action to remedy the situation and bring it in conformity with the state's international human rights obligations, the current Dutch government reacts in a hostile manner. For those of you who don't recognize them on the screen, the 3 men that are there are 3 leading figures in the current Dutch government. Well, in or behind the current Dutch government. The September 2010 coalition agreement that formed the basis for the formation of this new Dutch government announced an intensification of the state's return and deportation policy, in which families with children, and I quote, will receive priority. In relation to unaccompanied minors, the agreement states that, that's another quote, every effort will be made to effect their return. The logic followed by the current Dutch government seems to be that, as children relatively quickly build up firm rights, as is recognized in international human rights law, and as is confirmed in judgments by European and increasingly also national Dutch judges, children have to be forcibly returned to their country of origin as soon as possible. On a more general note, the coalition agreement contains no less than 11 references to new policy initiatives which are likely to clash with existing international obligations of the Netherlands, again especially in the area of immigration. Rather than implementing those obligations, which are laid down in treaties and in EU regulations, the new government proposes to renegotiate them. Where such renegotiation will not yield results, as far as bilateral treaties are concerned, these will simply be terminated. These attacks on international law are disturbing expressions of the changed climate among leading politicians in the Netherlands as regards the rule and role of international law. This presentation of selected achievements in realizing children's rights and of more than a few challenges indicates that the picture is enormously diverse. While impressive progress has been achieved on some, for other child rights disparities have deepened, and in yet other areas one can even see regression taking place. In the next part of this lecture, I will map out the extent to which the Convention on the Rights of the Child has contributed to the aim of universalizing children's rights, in the sense of their true acceptance and implementation over time. For a paper record is one thing, but a real contribution is quite another. In preparation for those of you who may have difficulties to imagine what the CRC is and what it is about, we will now view a very short UNICEF video, which was produced for the convention's 20th birthday last year and was kindly made available by the Dutch UNICEF office for use today.
Cheap labor, obedient soldier, child bride. Throughout history, children have been subjected to the worst forms of exploitation and abuse. After World War II, the groundbreaking Universal Declaration of Human Rights declared that children needed special care and protection. As a result, in 1989, the United Nations adopted a revolutionary treaty that gave rights to all children everywhere. The Convention on the Rights of the Child. It is the most ratified treaty in the world.
The Convention calls on all of us to help the children of the world. We all have to turn the promises of the Convention into a reality on every part of the globe.
By signing the treaty, nations promise to set basic standards in healthcare, education, protection, and social services. They also grant children the right to play, to express themselves, and to have a say in decisions that affect them. But the Convention has a grander vision, to change completely the way we see children as people not with needs, but with rights. As the global community commemorates the 20th anniversary of the Convention, we recognize that many challenges remain before all rights for all children are achieved. However, we have witnessed the power of the Convention to transform lives. Because of the world's commitment over the past 2 decades, more children today are surviving, more are attending school, more have access to clean water, and more are being protected against deadly diseases. For these rights to be recognized by all people everywhere, that is the dream of the Convention. Making that dream a reality for all children is our greatest test. Can we rise to the challenge?
So, according to UNICEF, the CRC is a revolutionary treaty that gave rights to all children everywhere. Let us now investigate the correctness of that statement by exploring both theoretical and practical perspectives on the question whether the Convention has indeed helped to universalize children's rights. That is, whether it has helped to advance understanding, acceptance and realization of children's rights in our diverse and unequal world. According to the Dutch Advisory Council on International Affairs, universalization is a process by which human rights come to be realized. According to this conceptualization, universalization should reduce the gap between principles and practice and covers a number of separate actions and processes that should take place within a given cultural, religious, social and political context. Among such actions and processes are increasing knowledge, awareness and popular acceptance of human rights, the implementation and legal enforcement of human rights norms, their mobilization in addressing social concerns, and the actual realization of human rights by all economic, political and legal means. This position reflects the state of the art of the debate about the universality and or the relativity of human rights. The former concept denotes the thought that human rights are ideas, norms and values that are globally applicable across cultures, economies, geographies, gender and so on. Relativism denies or challenges the general applicability of human rights, or at least automatic applicability, by arguing, for example, that every society is a morally self-contained whole, as a consequence of which certain features of human rights ideas, norms and values might not apply. Relativism has found its strongest expression in connection with cultural practices and identities. In the late 1980s and throughout the 1990s, the universality relativism debate in international relations was particularly fierce. Since then, the theoretical debate has settled on a solid middle ground position between the two notions. A middle ground, as formulated by Abdullahi Anaim, of neither taking normative universality in human rights for granted, nor abandoning it in the face of contextual specificity or cultural relativity. And this position is since reflected in international policy documents, human rights instruments, among practitioners and in academia, which introduce terminology such as pluralist universalism or mitigated relativism. This process of finding a middle ground was stimulated by the inescapable factual reality that in the end, all human rights norms will have to be applied and realized in a particular economic, historical, social, political and cultural context. And regardless as to whether or not a particular normative framework explicitly allows for contextualization, the particularities of that context inevitably influence the scope and direction of implementation efforts. For example, human rights consciousness, knowledge, data and financial resources are all important prerequisites for a competent recognition of human rights problems and for developing adequate responses. While thus it is unavoidable to consider context when applying international human rights instruments to specific states and specific situations, and to recognize the need for giving space for diversity, indicating the boundaries to an accommodation of diversity is extremely difficult and complex. And from a purely pragmatic point of view, the utility of doing so might even be questionable. And yet, international law has recognized a core set of universal norms and implementation principles that should be upheld at all times and everywhere. Across many circumstances, implementation capacity in the first place is very much a matter of political will. Secondly, this political will should combine with a country's technical, financial and other required capacity, knowledge and skills. Dialogue and pragmatism, or what Michael Addo has called a policy approach to issues concerning cultural practices and international human rights obligations, seems to be reasonably effective. According to Addo, tensions between cultural diversity and universal respect for human rights can and must be managed or proactively resolved. He suggested that the United Nations human rights treaty bodies, especially in the state reporting procedures, have found an appropriate way for performing this task. According to Addo, the treaty bodies do well to avoid the polemicism that has generally characterized the bulk of the scholarly debate. And they aim to strike a credible balance between the universal ideals of human rights and the reality of their implementation in different national and cultural contexts. In more general terms, a process approach which conceives human rights obligations as contextual and as to be realized progressively, and culture and the economy as dynamic and thus changeable, seems to be an important key to a successful balancing of the universal and the relative, or the universal and the context. An example may be found in efforts to ban the practice of female genital cutting through the introduction of alternative rituals to mark passage from girlhood to womanhood. In any case, the reconciliation of human and children's rights notions and the particularities of the context in which they arise require one to actively forge connections between them. This is referred to by some, including Sally Engelmary, as translation, vernacularization or localization of international human rights standards. And while this rarely be an easy process, at the same time, across contexts, there will always be entry points for making connections that are required and desirable. But obviously there is no guarantee for success. Another theoretical aspect which underpins the idea that there is a workable middle ground between universal and relative understandings of human rights lies in the acknowledgement that human rights instruments are in most cases not absolute in their conceptualization nor in their application. Most instruments allow for temporary derogations in order to protect certain prescribed interests, such as national security, public health, or order. Most also allow states parties to opt out of certain obligations through registering reservations. And both courses of action restrict the application of certain elements of international human rights instruments for particular states, and thus provide space for accommodating diverse interests, needs, and understandings. In academic contributions, especially in anthropological literature, the CRC has regularly been labeled as being a Western invention and/or imposition, or a global human rights instrument unfit for the daily realities in developing countries. Such criticism typically portray the CRC as overprotective of children, idealizing childhood as a time of play and preparation for adulthood, or even infantilizing developing countries. The latter term is used to characterize the effect of imposing allegedly Western models of childhood through the Convention on developing countries, which, it is argued, cannot comply with such models. This denial of their realities infantilizes them, so it is argued. Such critiques often lack nuance and are often not informed by in-depth knowledge of the CRC regime and its implications. They have been countered by many, including prominent scholars and activists from developing countries, such as Savitri Punesekere, eminent lawyer from Sri Lanka, in her book Children, Law and Justice, a South Asian Perspective. Canadian scholar Sonia Grover, in a 2010 article, refuted the infantilization position as follows: both Western and non-Western children are in dire need of protections, and they have equal entitlement to security of the person. In Grover's view, there can be no more profound way in which to infantilize the South than to remove the state obligation to protect the rights of children in the developing world. This, however, does not mean that the exact features of children's rights and of the obligations to realize them will be precisely the same across all contexts. Simply accepting the criticisms to which I referred just now results in arguments in favor of exceptionalism, and these carry great risks for the realization of human rights in general and children's rights in particular. Instead, another approach is possible, and in fact advocated by the CRC. Contrary to what the criticism suggests, the Convention provides ample space for accommodating diversity. While some elements of the CRC, such as the general principle of the best interest of the child, may certainly have roots in purely Western concepts, these have globalized and are now constructively worked with across different environments. And in the written version of this lecture, I elaborately substantiate the position that, on the whole, the Convention deliberately accommodates diverse implementation contexts and is relatively flexible. Accordingly, it has found a workable balance between universal and relativist notions of children's rights. With an eye on the clock, I will only share a dramatically summarized version of this position with you now. The CRC's sensitivity to context and contextual implementation did not occur by chance. Rather, it was an outcome that was consciously striven for during the drafting process. In the last substantive CRC negotiation round in November-December 1988, 19 Western 6 Eastern European, 15 Asian, 9 African and 8 Latin American states took part in one or more of the sessions involved. And on all main issues that were controversial or that were marked as controversial for cultural, religious or socio-economic reasons, compromises were found that noticeably responded to the different positions held by the participating states. And this paved the way to consensus over the text and perhaps also to swift ratification by so many diverse states afterwards. The CRC accommodates diversity in the first place through the contents of several of its key substantive provisions. The very definition of who is a child is left somewhat open to context. According to Article 1, a child is every human being below the age of 18 years, unless, under the law applicable to the child, majority is attained earlier. This leaves space for national adjustment, should this be found desirable. I already mentioned the best interest of the child. CRC Article 3 posits this as a general principle to be applied in all actions concerning children. That is, in all efforts made to implement the Convention. But nowhere in the Convention do we find a definition of the term. The underlying idea is that in this way, by introducing a mandatory but undefined general principle, local appliers of the Convention are obliged to search for appropriate interpretations. And while doing so, they then have to consider the detailed situation of the particular child or children involved, the specifics of national and local circumstances, and the nature of the decisions to be made. In other sections of the Convention, references to evolving capacity, age and maturity of the child, and to appropriate action also provide ample space for bringing in contextual elements, both in relation to the child, her or himself, and in relation to her or his everyday surroundings. Other CRC provisions clearly show sensitivity to context in relation to specific issues. Article 5, which addresses parental responsibilities, rights and duties, acknowledges that children grow up in diverse family circumstances and in diverse family or community settings. It defines a wide circle of possible caretakers of children, including not only the nuclear family, but also extended families and members of the community as provided for by local custom. Article 20 on alternative care shows sensitivity to legal pluralism and to the fact that certain concepts known in one legal system, such as adoption, may not exist in another. Among others, in light of socio-economic realities, Article 32 of the Convention deliberately does not ban child work, but it seeks to protect children from economic exploitation and from labor that interferes with their education, health, or personal development. Besides such substantive provisions, the Convention also accommodates diversity by assigning differentiated implementation obligations. According to Article 4, states have to take all appropriate measures to realize children's rights. In relation to economic, social and cultural rights, they shall do so to the maximum extent of their available resources and where needed within the framework of international cooperation. This is a straightforward response to the factual reality that most developing countries are confronted with large challenges and may only have limited capacity to address them. Acknowledging economic diversity and the differences in implementation capacity that result from this, and incorporating that into the formulation of state obligations under the CRC, is a crucial addition to the slightly more traditional recognition of cultural and legal diversity to which I referred before. By no means does this entail that states are not obliged to mobilize resources for children's rights, for realizing children's rights themselves. For example, the UN Committee on the Rights of the Child has developed a notion of what one could call the best available budget as a test for government commitment and determination. Accordingly, in order to be found to be meeting their CRC obligations, all governments will have to provide credible arguments, substantiating that they have mobilized the best available budget within their circumstances. Other CRC provisions refer to realizing child rights to the maximum extent possible by all feasible measures or by endeavoring to ensure protection. The needs of developing countries and the obligation to promote and encourage international cooperation are also specified. Accordingly, those states that are in a position to assist others through international cooperation are obliged to do so. In the past, the Netherlands, at the time especially under the leadership of then Dutch Minister for Development Cooperation and now ISS colleague Jan Pronk, indeed developed initial policies on CRC-related international cooperation through the document First Steps, a policy memorandum on children in developing countries. Unfortunately, these efforts largely withered away over time. Further indications that the CRC seeks to engage with diversity and context are found in provisions related to both the composition and the mandate of the UN Committee on the Rights of the Child, the body charged with monitoring the implementation records of state parties to the Convention. The committee has developed a practice of emphasizing the identification of obstacles to the full realization of children's rights and of ways to overcome them. Again, this opens the door to full contextualization. Obviously, there are also risks involved in this openness and flexibility on the side of the CRC. A fair amount of interpretation and expert knowledge of the countries involved may be required in order to apply the Convention to concrete situations. States may also be tempted to regard flexibility as an open-ended escape clause. However, as addressed earlier, despite the risks involved, it is very clear that contextual implementation and accommodation of especially cultural and economic diversity is an unavoidable feature of a modern international human rights instrument. The relevance of the contents of the CRC across diverse contexts is underlined by the empirical record of nearly universal ratification, which was achieved in less than a decade. In the context of criticism of alleged Western and our cultural biases, it is interesting to note the regional trends in the ratification patterns. Obviously, one should realize that ratifications as such, even if registered without any reservation whatsoever, are not necessarily a reliable indicator of full state support for the treaty involved. Ratifications do not necessarily improve the child rights records of the states involved. Certainly, many serious violations of children's rights persist across the large majority of all state parties to the Convention. Nevertheless, the very fact that, with 193 ratifications, it is the most widely ratified human rights treaty in the world, remains a telling achievement. The chart on the screen shows trends in the ratification patterns of states in the various regions of the world in the first 7 years of the CRC's existence. Statistically, the Americas and the Caribbean and Africa, represented by the light and dark blue lines at the top of the chart, consistently scored higher in terms of CRC ratification percentages than Europe did, represented by the middle line. Asia and the Pacific, the second yellow line, surpassed Europe in the course of 1995. Meanwhile, the Middle East and North Africa, the pink line at the bottom of the chart, clearly lagged behind, especially during the mid-1990s. However, by 1997, they too had achieved a 95% ratification rate, compared to 96% for Europe. While the category Europe in this chart encompasses Western, Central and Eastern European states, the trends in Europe's ratification record were brought about more or less equally by all three groups. Another empirical indication of worldwide engagement with and action on the CRC across developed and even more so developing countries is found in the extent of law reform efforts and to a lesser extent national jurisprudence triggered by the Convention. These points are further elaborated in the written version of this lecture. A conclusion arrived at is that, while in countries such as South Africa, reasonable comprehensive legislation is now in place, and the CRC has had a truly visible impact on judicial decisions, in other countries, especially in those countries that have not yet adopted comprehensive children's laws, such as the Netherlands, the impact of the CRC on national legislation and jurisprudence has been too small. Finally, the very fact that so many international, but especially also national and local civil society actors have also committed themselves to the Convention on the Rights of the Child and seek for ways to develop and operationalize CRC-based approaches to their daily work is also a significant indicator of the broad support base for the Convention and its mission. Has the CRC come of age? A few concluding remarks. This lecture has shown that UNICEF was correct to characterize the CRC as a revolutionary treaty that gave rights to all children everywhere. The CRC represents a mature human rights regime, especially because it is so much interested in finding ways to accommodate the greatly diverse circumstances and contexts in which, inevitably, children's rights are to be realized. From here, a fascinating research agenda unfolds. More information about and analysis of the ways in which the Convention accommodates cultural, economic, and other forms of diversity in practice would be extremely useful for academics and practitioners alike. How does such accommodation take place and why? What are the outcomes? What incentives and constraints for realizing children's rights have been revealed in the process? Generating rigorously documented and critically analyzed evidence of good and bad practice in the field would make a welcome contribution to the still mostly experimental, theoretical and field work in this realm. Obviously, all of this praise by no means implies that the CRC regime is perfect. This is barred by the fact that far too many children in far too many countries are still subject to violence, deprivation, neglect and other violations of child rights. Then, as again elaborated in the booklet, mainstreaming of children's rights, a complaints mechanism for the Convention, currently campaigned for, greater and deeper implementation capacity, more data and resources are badly needed. The Convention is also clear that the needs of developing countries require special consideration and that international cooperation is an important prerequisite. However, far too little of this has been realized. Against this background, both the content and the implications of international cooperation obligations in the framework of the Convention also pose pertinent questions for both research and activism. We have now reached the end of the substantive part of this lecture. Today is also an occasion for a few public words of thanks. While many have my gratitude, everybody in this room has my gratitude for being great partners in academic and other work, only very few can be mentioned by name here. Again, there's a longer version in the booklet. I thank the Executive Board and the Board of Deans of Erasmus University Rotterdam for their decision to appoint me Professor of International Law and Development. I am grateful to the Vereniging Trust Fonds Erasmus Universiteit Rotterdam for its contribution to the creation of my chair. Former ISS Rector Luc de la Rive-Box played a crucial role in relation to the establishment of endowed professorial chairs at the Institute, for which I sincerely thank him. In addition, Luc, I will never forget how you, in relation to some of my academic work on Western Sahara and Palestine, stood up for academic freedom. In relation to my academic formation, three people immediately come to my mind. Professor Peter Kooijmans, who was my LLM thesis supervisor at Leiden University, and Professors Paul de Waard and Nico Schrijver, who were the most inspiring team of promoters at the Vrije Universiteit Amsterdam that I could hope for. In addition, Nico was instrumental in introducing me to the pleasures and pains of academia and in putting me on the path of studying international law and development. It is probably no coincidence that all three of these people are men, as the percentage of women professors in the Netherlands is still shamefully low. I sincerely hope that many more women will climb to the highest academic rank in the years to come. And whenever possible, I will certainly do my share in trying to bring this about from my new position. The ISS has been a great professional environment for me since I first joined it as an intern. I'm deeply grateful for all the opportunities that the Institute gave me to develop myself and to discover my talents and priorities. The ISS students especially have been a joy to work with. Throughout, your eagerness to learn and your willingness to share experiences and to celebrate diversity have been extremely motivating and rewarding for me. I look forward to having many more critical debates and exchanges of arguments and views with you. I also thank my ISS colleagues, technical, administrative and academic, for the fruitful working relationship that I have experienced among them. I mention in particular staff group 2, my international law colleague Jeff Handmaker, and the teams that have been involved in developing and delivering the ISS MA specializations in human rights and in child and youth studies. My parents, Toon and Nell Arts, are always ready to support me and my family, and they are great grandparents for my children. I also cherish the good relationship with my sister and brother Manon and Jeroen Arts and their families, all sitting at the front row. The saying goes that behind every great man stands a great woman. Well, in this case, behind this woman stand 3 great men, Aart, Fabian and Ramon Biondina. Without your support, I would definitely not stand here today. Fabian en Ramon, jullie gaven mij een belangrijke tip voor de PowerPoint-presentatie die ik vandaag gebruikt heb. Om die niet al te saai te laten zijn, moesten er volgens jullie veel plaatjes in. En een bewegend plaatje van een professor. Ik heb naar jullie geluisterd. En deze is voor jullie. Ik heb gezegd:
Thank you very much, Professor Arts. I congratulate you, but you clearly argued, lively presented. I would say nowadays they call this an enriched presentation. And of course on the acceptance of your professorial chair. You have raised relevant issues which will be an inspiration to us all. Your analysis of the UN Convention on the Rights of the Child show that right-based approaches are relevant to development and to international development studies here at ISS. International law can contribute, does contribute to development with equity and to positive social change. We have clearly demonstrated that potential. And you also show that the diversity which the Convention allows, or even aims for, is an interesting perspective for others, for other issues as well to look upon. It also puts responsibility on, as you say, countries which are at a more advanced level of progress or development to support others in meeting their obligations. But on the other hand, it should not be an excuse of downplaying stricter immigration rules and increased xenophobia in our societies. Thank you for pointing that out to us. And again, congratulations, and I extend my congratulations to your 3 big men behind you.